Mark Fancher, I'm with the ACLU Michigan. First of all, let me say that your presence was known, it was heard thanks to our brother Herbert Sanders, who let the court know in no uncertain terms that this really has everything to do with you. He put it plainly before the court that they have to decide between two competing philosophies. One philosophy that's offered by those who want to uphold this law, which says that it is difficult, they want to make it difficult for the people to be heard, to petition their government. On the other hand, it is a philosophy which has been enunciated by this court and by other courts in this state for more than 3 decades, that the people have a right to petition their government and to make their voice heard and to legislate directly whenever their representatives do not do it for them. Right. So that is the question that is before the court. There is no way for us to know how the court will decide on this, but we do know that they were pushing a position on the other side for this to come down to a question of whether this has to do with font size, whether it has to do with 14-point and what that means. You know, Mr. Sanders made it clear that we can argue over these little details all that we want. In the past, we have argued over silly little details when the question of whether there was a right for people to be integrated into certain schools was present, whether women would have the right to vote, whether there should be discrimination against Jews and other minorities, whether it should be any kind of thing, and they always come down to these little silly questions, these little technical issues, and ultimately the real issue is whether you as the people will have the right to go and to be heard at the ballot box.
That's right.
And so that is the question that's before the court. We stand by and we wait to see what they will have to say. But I do want to tell you that, as I said, Mr. Sanders made it clear that you were down here and that you were looking and that you were watching the court. Do not stop coming. Do not stop mobilizing. Do not stop making your voice heard. Because if they don't listen, somebody ultimately will have to listen, because it is the people who are in control. It is the people who are supposed to drive government. It is the people who are supposed to make decisions. Not only do we say that, but the Constitution of Michigan says that. The Constitution of the United States says that. And if we want to protect that, then we have to remain vigilant.
That's right.
We don't know yet.
Can I ask a question? Can this be taken to the federal level if state Supreme Court rules against us?
We have to take it one step at a time.
How close does this rank to Nazi Germany in Hitler's policies in terms of function and process, if you know?
We're not there yet because we're still in court.
Well, but I'm just saying, it's feeling that way.
If you don't want it to get there, then you'll continue to remain vigilant.
Wait, I have a question. The font itself is standard. Is that correct?
Well, the argument was over whether the court raised the question of whether you're talking about 14 points versus a particular font.
No, the standard that you get when you go to run for office, they give you the paper, right? Is that standard?
I can't answer that question.
Well, you can't run and make up your own petition. You have to go to the election commission to get it from them. And then they tell you if you run out, come back for more, or you can run it on another legal paper. So they are the ones that make the standard. And my question to you is, if that's standard, why is not we checking Snyder's election, because he needed signatures, just like we need a signature here. He had to use the same launch.
Hey, stay on point. We're talking about Public Act 4 and whether you're going to have a chance to go to the ballot box.
Okay, I have a question for you. Okay, my question is the issue pertaining to the issue right now in the court, is there precedent pertaining to font size on petitions? Yes or no?
There are a couple of cases that were cited by the other side which dealt indirectly with that issue in the form of orders, unpublished orders, which did not have opinions attached to them, which spelled it out in great detail. The binding precedent is the case that deals with broader issues, and that is one that the court did take note of, and I'm certain that they will give attention to.
Is that, in fact, the issue that